Hey, I'm Mike Alder. Thank you for watching this. You know, our firm got notice of a remote jury trial that's coming up, and we had more questions than we had answers. And we figured, you know what, why don't we just try to do a mock trial remotely? We'll film it and we'll see how it comes out. So I called one of my good friends, Mike Schonbuch, one of the best defense lawyers in the country. Another very good friend, Judge Brian Hill, a Superior Court judge here in California. We had 8 jurors and we had 4 witnesses. So we recorded the entire trial, and then we're going to show unedited it in 3 separate sections. And the second session is going to be opening statements and the direct and cross of 4 witnesses, a plaintiff, a defendant, a plaintiff's expert, and a defense doctor.
So, as I promised, the attorneys now have the opportunity to make opening statements. Mr. Alder, would you like to make one?
Yes, sir. Thank you. I would. All right. Good morning, everybody, again. My name's Mike Alder. I represent the plaintiff, Mr. Plaintiff, a 38-year-old man with no problems, no pain, no history of any problems, who got rear-ended by the defendant. And from that time until the present, over the last year and a half, has had medical problems. And I just want to start by thanking everybody for being here. Believe me, we all know, Mr. Schonbuch, as he said, you know, given our gray beards, we've done this for a long time, and we understand seeing people sacrifice to be on a jury is a big deal. And I just want to acknowledge that on behalf of my client. Thanking you, really appreciate it. And you know, you're going to hear about, you've already heard in voir dire about accepting causation. Well, this case is about just because you begrudgingly accept that you caused an accident, because there's no other alternative, right? She wasn't paying attention and she rear-ended the plaintiff. It's totally different than accepting responsibility. Because in voir dire, Mr. Schonbuch said, you know, there's really no dispute about how this accident happened. And I submit that's absolutely false, because you're going to hear completely different versions of what happened. And one of the things we look forward to is presenting the evidence, which I'm going to tell you about in just a minute, that will show you that really from the time of this accident until now, the defendant says, well, yeah, I caused it, but denies everything else to a point where they're going to call a hired doctor that they have paid well over $10,000 to say that the plaintiff was not hurt in any way and should receive 0. Not a difference of opinion, but 0. That's why we're here. We need your help to look at the facts. So what happened? April of last year, April 2nd, Mr. Plaintiff, 38-year-old man, going about his business, healthy, happy, stops at a stop sign and gets hit from behind. You're going to hear 2 different versions. Mr. Plaintiff is going to talk about how from the get-go, Ms. Defendant was antagonistic and yelling. You're going to hear the opposite from the defendant. So how do you make a decision? Let's talk about the evidence. Both parties agreed to call the police. The police get there and they look at the scene and they talk to both parties. And Mr. Plaintiff, not feeling that bad, legitimately, responsibly says, I think I'm fine, I'll be okay. No police report was taken, not unusual. And as a lot of times happens, over that day, Mr. Plaintiff began to develop more and more problems. Ultimately, he goes to the emergency room that night and talks about soreness and pain in all of his shoulders, his back, and his low back. They take x-rays, and luckily he has no broken bones, and they tell him, if your pain keeps going, come back. And I want to show you what has happened now over the year and a half. This is very common. Most of Mr. Plaintiff's pains in other parts of his body went away with time, except for the problem that was caused by this accident, his low back. Mr. Plaintiff, when the pain doesn't go away, goes to see an orthopedic doctor who takes an MRI and finds that in his lower back, that this 38-year-old man has something that is unusual in a bulge in his back that was likely caused by this accident. And it just so happens that that bulge that they see on the MRI is exactly where he's having pain. Not unusually, he then tries to have conservative treatment and has a shot in his back that temporarily relieves his pain. A couple months later, it comes back. He tries conservative treatment again. Temporary relief comes back, tries it again and again, and ultimately is told by an orthopedic surgeon that, look, this temporary pain relief is not going to help long-term. You're going to need surgery. And so at the beginning of this year, a treating doctor with no agenda has tried conservative treatment for Mr. Plaintiff and says, you need surgery. And because of COVID-19, the plaintiff is just waiting. Now, everything that you're going to hear from the plaintiff and from his doctor is consistent. Conversely, the defendant is going to say that Mr. Plaintiff needed none of that care, had no injury, and I guess by insinuation has made all of it up and is lying about all of it. Ladies and gentlemen, this is not some number that the plaintiff is pulling out of the air. We will be asking for reimbursement of $72,250 in incurred medical care. This isn't pie in the sky numbers. This is what happened to the plaintiff, that he had no pre-existing problems in any way. The surgery that has been recommended, once COVID-19 allows him to have that surgery, will cost $35,000. We are going to be asking for $107,250 in medical care. The plaintiff is 38 years old. Unfortunately, when you have a surgery, the type that is being recommended, it wears out after about 20 years. And the pain that initially is helped by the surgery starts to come back due to arthritis and aging. So this 38-year-old man at 58 is going to have problems. At 68, he's going to have more problems. And although we're not asking that you award any future surgery care, because it's not going to be bad enough to have another surgery, this is going to be a lifetime problem. So we look forward to presenting this evidence, and I'd ask that you weigh if what the plaintiff is saying in his direct about the accident is consistent with his behavior over the next year and a half. And conversely, apply those same standards to whether what the defendant is saying about the accident complies with the behavior and what their experts describe. And I think you will see a radical difference. And if you see that the plaintiff has proven their case more likely than not, in other words, if you think probably the plaintiff is right and the defendant is not right, just probably, then we would ask that you award $107,250 to the plaintiff. And because of a 40-year history of future pain, another $250,000 in pain and suffering. I want to thank you again for your attention. I can see how attentive you all are already. We will be fast, we will be efficient, but we will be thorough so that you have all of the information you need to be fair. Thank you very much.
Mr. Alder, thank you. Mr. Schonbuch.
Thank you very much, Your Honor. Thank you.
You may proceed.
This trial is about a difference of opinion. It is a dispute over the amount of money that plaintiff should get, if any. This was a minor accident with minor injuries, if any, and plaintiff's verdict should be at most a small amount of money to reimburse him for the inconvenience of having to go to a doctor just to get checked out. At the end of this trial, I'm going to be asking you to find in favor of Ms. Defendant. This accident is what's called a fender bender. It's a small accident with a minor impact. There was some minor damage to plaintiff's Prius, which was all plastic and cosmetic damage to this car. There was no damage at all to Ms. Defendant's Ford. Not a scratch, no repairs at all, because this was such a minor accident. Plaintiff's airbags in his Prius did not deploy because this was such a minor accident. The police were called by Ms. Defendant, but no report was made because this was such a minor accident. No ambulance came because this was a minor accident. No paramedics were summoned because this was a minor accident. In fact, plaintiff left the scene and went to work the entire day because this was such a minor accident. When he finally goes to the doctor that night, he admits to the doctor it was a minor impact and says the impact was light. All x-rays that were taken that day were completely 100% normal because this was such a minor accident. The MRI that plaintiff eventually took, the first set of MRIs, first, the MRI of the neck was completely 100% normal, again, because this was such a minor accident. The first set of MRIs to the low back showed things called degeneration, desiccation, and degenerative disc disease. Things not caused by an accident, things that are called pre-existing and due to the process of aging. Later on, plaintiff had more MRIs taken. And again, the MRIs of the low back, the later second set, showed something called degenerative disc disease, something not caused by this minor accident. Because we have a dispute in this case about the severity of the accident, yes, Ms. Defendant was forced to hire an outside doctor to review these records and compare it to the fact that she says there's nothing here. This was the smallest little tap. But facing a lawsuit, and under the law, Ms. Defendant is allowed, she's permitted under California law to hire an outside doctor to review the records and review these MRIs and tell her, are we missing something here? Anyway, Ms. Defendant hired the outside doctor who conducted a series of examinations, reviewed the records, reviewed the films, and when I say series of examinations, examined the plaintiff. All the examinations by this outside doctor were 100% normal. Gait, which means how the person walks, range of motion, which means can they move, can they bend, can they turn to the side, a series of medical maneuvers with a bunch of fancy terms that we will let the doctors explain to you what each one means, but they were all 100% normal. Things like motor strength, reflexes, every single thing was normal, except for plaintiff subjectively saying, ouch, that hurts. This trial is about a difference of opinion. It's a dispute over the amount of money plaintiff should get, if any. This was a minor accident with minor injuries, if any. Plaintiff's verdict at the end of this case should at most be a small amount of money to reimburse him for the inconvenience of having to go to a doctor just to get checked out. And at the end of this case, I'm going to ask you all to find in favor of Ms. Defendant. Thank you very much.
Mr. Schonbuch, thank you. Mr. Alder, your first witness, please.
Honor, may I request a brief recess to use the facilities?
Yes. Ladies and gentlemen of the jury, how long do you need, Mr. Alder? Get too personal.
Your Honor, I need 1 minute.
Why don't we say, because you're probably not alone, so the court needs a break as well. So why don't we take, I have 10:30, why don't we take to, how about 5 minutes enough for everybody? Let's go to 10:35. We'll take a 5-minute break. Remember, during the break, don't discuss the case among yourselves or anyone else. Don't
Thank you, Your Honor.
go to any reference materials. We'll see you back in 5 minutes.
Thank you, Ron.
All right, back on the record in the case of plaintiff versus defendant. All jurors are present, attorneys are present, and parties. Ladies and gentlemen, thanks for being right on time. Just a reminder, we need you to be on time. It's going to delay the trial. So I appreciate it. The attorneys appreciate it as well as the parties. And as just before the break, I think I was indicating to Mr. Alder that he could call his first witness. Mr. Alder, go ahead, please.
Yes, sir. Thank you, Your Honor. The plaintiff would call the defendant, Ms. Defendant, is our first witness.
And the defendant, please just rise, or I think for our Zoom trial, just raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, very good. State your full name, spell your last name for the record, ma'am.
Miss Defendant, Defendant.
Mr. Alder, you may proceed.
Thank you, Your Honor. Good morning, Ms. Defendant. How are you?
Morning, sir. I'm fine.
Okay, good. So I want to take you back to April 2nd, 2019. You ran into the back of a 2015 Prius. Is that right?
I bumped a Prius, yes.
So yes, you ran into the back of a 2015 Prius, correct?
Oh, okay.
All right, and so we'll talk about bumping the Prius. However it was, you agree that you caused an accident, yes?
Yes.
Is that really hard to admit?
Well, I didn't think I hit the vehicle. So, because I was behind him, does that mean I'm responsible for that? Yes.
So it actually took you a little while to figure out that there was even an impact and whether you had done anything wrong, right? It was so minor.
Yes.
So you must not have been driving very fast at all when you hit Mr. Plaintiff?
No, not at all.
Can you give us any estimate of how fast you were going when you hit the stopped Prius in front of you?
Well, I know he had slowed. I think he was looking to turn into a driveway or something. So since he had slowed down, I slowed down. So my best estimate would be 4 or 5, maybe 6 miles per hour.
Okay. So you saw Mr. Plaintiff long enough to see him slow down, long enough for you to determine that it looked like he was going to turn right. And yet you were going at a speed that prevented you from stopping before you hit him?
Well, I didn't say he was going to turn right. I said I thought he was going to turn into a driveway. I don't know if it was going to be left or right. I was behind him. I saw him slow. I slowed. I didn't know he had stopped. I didn't see brake lights or anything.
So, ma'am, you understand that now that you have admitted that you caused the accident, plaintiff did nothing wrong, that this is a question about whether what you did to him actually caused him pain, suffering, medical bills. True?
That's what I've been told, yes.
So did you make a determination at the scene as to whether there was, in fact, an impact between the cars?
Ultimately, yes. Initially, I did not think the cars hit. I learned later they had.
So we've already heard from you that you didn't think you even hit the car, but then you got out and you looked. Did you see any damage between?
There was no damage to my car whatsoever, but I did see scratches to the Prius.
And did you see anything other than scratches?
You could see where the metal had kind of crinkled a little bit.
Okay, so what I want to show then, Your Honor, I'd like to approach and show the witness exhibits 1-4, 1-6, and 1-7.
Mr. Schonbuch, have you seen those exhibits?
Yes, I have, Your Honor.
No objection?
No objection, Your Honor.
You have a screen, Mr. Alder, you want to put those up for the jurors?
Yes, if I could ask the technical to put up 1-4. Please.
Okay, you may do so.
So ma'am, looking at it sideways, is that what you saw, the back of the plaintiff's Prius? Is that what it looked like at the scene?
Yes, it looked like my grill had touched it.
Mr. Alder, do you have, can you, it's a little hard to see it. Is there a way you can move that, swivel that exhibit around?
Yes, Your Honor, if we could try to do that, Edward.
Might be helpful.
Can you show it? Great. There you go. So
Thank
let's do 1-6, please. Got 1-6.
So Mr. Alder, the exhibit that was just up was 1-4.
Yes, Your Honor. And now I'd ask that 1-6 be put on the screen.
And Mr. Schonbuch, no objection to this exhibit?
No objection, Your Honor.
So, Ms. Defendant, you would agree, is this the damage you saw at the scene?
Well, the picture's kind of blurry, so I'm not sure that's all damage, but I did see the crinkle in the bumper, yes.
So when you put on your brakes, let's be clear, you said you didn't even think there was contact. Then I believe you said barely any impact at all. Then I think you said you were curious to see if there was any impact. You would agree that there was impact enough to cause the damage shown in the photos, right?
Well, I didn't get out of the car because I was curious to see if there was impact. I didn't think the vehicles had touched. So I got out of the car because I didn't know why he wasn't moving his car, why he had stopped, if his car broke down or what. So when I got out for that reason, yes, I then did see the marks on his vehicle, yes.
Your Honor, I'd like to read from the defendant's deposition on page 6, lines 15 through 18.
Give Mr. Schonbuch a chance to locate that. Do you have that, Mr. Schonbuch, in front of you?
Yes, I have it. No objection, Your Honor.
Go ahead, Mr. Alder.
So ma'am, at depot, I asked you, did you get out of the car? And your answer was, quote, "Oh yes, immediately. I was curious to see if there had been any contact at all." So in reality, ma'am, you were wrong. You misinterpreted the impact speeds and how bad this was. You even said, "I'm just curious. I didn't even think I hit him." You'd agree you were wrong, right?
I'm not sure I understand. I didn't think I hit him. I got out of the car. Then when I saw the vehicles had touched, I was curious to see what damage. yes, there were some scratches and some small dents. Yes.
So the vehicle impact that you were curious to see if there was any contact, that you didn't even know that there was a contact, that there was no noise. Any idea how this Prius got $5,000 worth of damage to it?
Well, I don't know who said it was $5,000 worth of damage, but I drive a Ford Explorer. It's a big car, and we know that the newer Priuses and cars like that are, from what I'm told, are made from really thin metal. So I don't know.
Last couple of points. Thank you for pointing out, the car you were driving was larger than the Prius, wasn't it?
I'm sorry, you cut out. The car I was driving what?
It was much larger, heavier than plaintiff's Prius, wasn't it?
It was a Ford Explorer. Size-wise, it's bigger. You said higher. Yes.
You'd agree that the jury has an expectation that the plaintiff is going to be truthful and honest and not exaggerate or understate the facts. True? Right? He should be truthful.
Do I have an understanding that the plaintiff is being truthful?
Ma'am, you'd agree that the plaintiff should be telling this jury the truth and not exaggerate or underestimate the facts. Would you agree with that?
I agree he should be telling the truth just like I am, yes.
That you would agree the jury should apply the same standards to you, correct?
Yes.
So we heard that your counsel said you were forced to hire a doctor. You know what his name is?
Do I know what his name is? Yes.
What's his name?
Plaintiff's defense expert.
Thank you, Your Honor. No further questions.
Mr. Schonbuch, questions for your client?
Yes, Your Honor. I would just request from our tech if we could take the photo down, please. Thank you very much. Okay, Ms. Defendant, can you tell the jury, were you on your way to work that day?
No, I'm retired. I'm a retired special needs teacher. I wasn't working.
Well, if you were not working, what do you do with your spare time now?
Correction, Your Honor, relevance.
Overruled, I'll permit it.
Does that mean I answer it?
Yes, that means you answer it.
I volunteer. I help train and raise guide dogs to help special needs children and blind individuals.
Okay, thank you. And I want to go to the day of the accident now. You saw the plaintiff slowing down, you said, so you slowed down as well. Is that what you just told Mr. Plaintiff lawyer?
Correct. He was driving very slowly.
Okay, and when you estimated the numbers, I think you mentioned some numbers of how the speed of your vehicle at the time of the accident. Was that the numbers of your speed before you slowed down or after you slowed down?
I had been going really slow for quite a while because he was going slow. So I think the last time I looked down at my speedometer, I was maybe going 4 or 5 miles an hour.
Okay, and is that the estimated speed that you think you were going when the actual contact happened, or at least when the plaintiff came to a full stop?
Well, again, I didn't know he stopped. I saw no brake lights or anything. So I probably had applied my brakes before that happened. So I could have been going a little less. I'm not sure.
Okay. Did you eventually figure out, now remember you said you thought maybe that Mr. Plaintiff was turning into a driveway or something like that. Why did you think he was turning somewhere or Or, what was going through your mind?
I didn't understand why he was driving so slowly. I hadn't ever been on that street before, so I wasn't familiar with what was around. But after the accident, when he was screaming at me, he kept saying I'd made him late for a meeting. He was going to miss the meeting. He was going to be late. So I presumed that he was looking for wherever the meeting was going to be at.
Okay. Now, you said, though, that he was going so slowly. Were you also therefore going so slowly?
Oh, yes, I had to, yes.
Okay. Did you ever figure out why it is he came to a complete stop at that location?
After I got out of the vehicle, I saw a stop sign. I had not seen the stop sign before because there was a tree blocking it. But when I got out, I saw it and presume he stopped for the stop sign.
Okay. Earlier, plaintiff's counsel asked you and read from your deposition about you getting out of your vehicle because you were curious to see if there was any contact at all. Do you recall that?
I recall him reading that to me, yes.
Okay. Did you feel any contact at all between your vehicle and plaintiff's vehicle?
No,
Okay. What was your reaction when you got out and saw that there was contact? What was your initial thought?
I was shocked, stunned.
Okay. And was that because you did not feel any sort of impact?
I felt no impact whatsoever.
Okay. Now, I want to go back to what you just said a moment ago. Plaintiff got out of his car, correct?
Correct.
Did he have any problems opening the door and swinging his body and getting out of the car?
Oh, absolutely not.
You said that he got out, he was screaming. Is that what you said?
He got out, he was screaming, he was swinging his arms around, he was yelling at the top of his lungs, and he first came at me.
Okay. Do you remember any of the phrases that he was screaming in your direction?
I don't know if I'm supposed to say this or not, but he was screaming, what did you fucking do? He kept talking about he was going to be late for this meeting. I was so afraid and shocked that I think he called me a stupid old lady. I'm not sure, but I think he did.
Okay. You also mentioned that he said he had a big meeting he had to go to?
Yes, he didn't say what it was, but he just kept talking about this meeting and he was going to be late for the meeting or he was going to miss the meeting. So I just figured that's why he was so upset and screaming at me and pacing up and down and calling people, and he was a little bit wild.
Okay. When you said pacing up and down, you saw him walking around at the scene?
Yeah. Yes, he kept going back to his car, then coming at me, then walking while he was on the phone, pacing back and forth while he was talking. Yes.
Did he seem to have any difficulty walking around at the scene of the accident?
Oh, no, not at all.
And you said he was on the telephone, he was calling people?
Yes, he was on his phone, he was calling people. I suggested we call 911. He said no. And I know he was talking about the meeting on the phone, so I presume he was talking to somebody about the meeting. And he just kept screaming.
Okay. You did call 911, true?
Yes, I did, yes.
And the police arrived, true?
Correct, the police did arrive.
Did they ever make a report about this accident?
No, I wanted a report because I've always learned if you're in an accident, you're supposed to get one. But the police said no, that no one was injured and there was so little damage that it just wasn't necessary.
Did the plaintiff in this case ever say to you that he was hurt?
No, he never said anything like that. He was just screaming at me and talking about the meeting.
Did he ever say that he was in pain?
No, not at all.
Did Mr. Plaintiff ever ask for an ambulance?
No,
Did any paramedics show up?
no,
Did he look injured to you?
no, not at all.
Did he act injured from your point of view?
No, that's why this whole thing shocked me later on.
You said your Ford had no damage at all. Is that what you said?
My car had no scratch, no dent, no paint, no nothing wrong with it.
It did. You're saying it didn't even have any paint transfer.
Nothing.
All right. Did you have any idea you would be sued in this case?
No, not whatsoever.
Lastly, were you hurt?
No.
Nothing further. Thank you.
Mr. Schonbuch, thank you. Mr. Alder.
Yes, ma'am, I just want to make sure that we're clear because this sounds like a really traumatic event where a man half your age jumps out of a car and starts screaming at you. You must have been pretty frightened, right?
Yeah, yes.
When you called 911, did you tell the cops about that?
Well, when I called 911, I don't think I talked to a police officer then, but the only thing I recall telling 911 was that there had been a minor accident and could they send someone.
Well, ma'am, so there was a minor accident. You didn't think there was really any damage. The plaintiff looked like he wasn't hurt at all. And you called the police. You're saying because of a minor accident where no one was hurt or because this younger man was screaming at you? Is it?
I called because I've always learned that you should call the police if there's been any kind of accident. But now that you ask me that question, was I probably scared and that's why I called them? Maybe.
So then when the police got there, this younger man who's running around crazily on the phone, screaming at you, scaring you, you told the cops about that and they decided not to write any of that down. You sure that's what happened?
Well, I'm sure that's what happened. I don't know why they chose not to write it down. They just kept saying, no one's injured. You've exchanged information. Go on your way.
Did you tell the police that this man was threatening you? You were scared of him.
I never used the word threatening. I said he was yelling at me and screaming at me and cursing at me.
Ma'am, you said there was no damage to your car and that you never expected you got sued. But after you got sued, you then sold the car and never took any photos, right?
Well, that's not correct. I never took any photos. I did sell the car, but I needed money, so I sold the car, but it was before I ever got paperwork about this lawsuit.
Okay. Last thing, ma'am, I just want to make sure because we're trying to figure out what exactly happened. You're pretty sure that you were going 4 miles an hour or less when you saw that you needed to put on the brakes. Is that your testimony?
Again, I apologize because you cut out a little bit, but my best estimate was 4 to 6 miles per hour.
All right. 4 to 6 miles before you put on your brakes. True? That's your best estimate.
Well, I had been applying my brakes as I was going up the street all along, so I'm not sure what you mean by before I put on my brakes.
Good enough. Thank you. Appreciate it. No further questions, Your Honor.
Mr. Mr. Alder, thank you. Mr. Schonbuch, anything further?
Nothing, Your Honor.
All right, Ms. Caruso, thank you. Thank you for your testimony. We appreciate it. You can step down, and Mr. Alder, your next witness, please.
Yes, sir. Thank you, Your Honor. The plaintiff would like to call Mr. Plaintiff to the stand.
Mr. Plaintiff, good morning. Mr. Plaintiff, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Mr. Plaintiff, state your full name, spell your last name for the record, please.
Mr. Plaintiff, Plaintiff.
Mr. Alder, you may proceed.
Thank you. Good morning, sir.
Good morning.
So you were in the courtroom when we just heard you being described as someone who was yelling at an old lady, calling her an old lady, harassing her, screaming. Did that happen?
No, not at all. Not at all.
What do you do for a living, sir?
I'm a music producer
Okay.
here in LA.
And you heard the defendant, Ms. Defendant, describe what happened. Let's talk about what you remember and what actually happened according to you. Where were you going when you had to come to this stop sign and stop?
I was going to work, normal day of going to work. Stopped at the stop sign, which I saw. And then after that, I just felt a boom. I heard a boom.
And is this, had you taken this route? Is this the normal route you took to go to work?
Yeah.
Is there any reason why you would be driving extraordinarily slow, like you were looking for something? If this was your normal
Not at all.
commute route? You stopped. As far as you know, your brake lights worked?
Yep. Brakes like work.
You got rear-ended by the Miss Defendant. Can you think of any reason why your lights wouldn't work enough that she could see them or couldn't see them?
No. Car was fairly new, in really good shape.
So tell us what you remember happening.
So after she hit me in the back, my body kind of jerked, and I just kind of felt like I just felt dazed, and I just didn't understand what was going on. So I was gonna just kind of try to get gather myself, and then I got out of the car, and because she was honking, so I got out of the car because of her honking, and trying to come out from this daze, and she's just screaming at me, yelling at me, saying that I stopped short. And I was like, didn't think I did. I mean, I stopped at a stop sign. And then I asked her, hey, well, maybe we should call the police. And she had said, well, she had already called the cops.
Okay. And so sounds like a radically different memory than what we just heard from Ms. Defendant.
Yeah, I wasn't cussing at her, and I was just dazed from the impact. I mean, there's no reason for me to cuss at her. I wouldn't do that.
Did the police come?
The police came. You
had told us that we're not yelling or screaming or doing anything. Was there any indication from the police that the defendant had told the police that you were screaming at her and harassing her or threatening her in any way?
No. He never indicated that to me.
I want to ask you about what happened next. We know that there was not a police report and that you went to work, correct?
That's correct. I went to work.
If you had not gone to work, would you have gotten in trouble? I mean, going to work, is that a bad thing?
Going to work is not a bad thing. I definitely would not. It would not have been a good idea for me to miss work.
Did you think instead like that somehow there was an opportunity now for you to make a bunch of money and maybe not go to work and make all this up?
No, not at all. I mean, after that, the whole thing of her kind of yelling at me and kind of blaming me for her rear-ending me, I just wanted to get out of there, and I just wanted to get to work.
Now, as the day progressed, did you start to feel the results of the impact that at least initially didn't seem as bad as it was?
Yeah, I mean, I started to get headaches. My neck started to stiffen up, started to get low back pain, and throughout the day, the pain just came on. I mean, it came on just kind of gradually, and then throughout the day, it just got worse.
So you worked that day, but started to feel pain. You worked through pain. Isn't that, I mean, like what we want people to do? Worked hard that day, yes?
That's correct, yeah.
Then did you have to go to the doctor at some point that day?
Yeah, I ended up going to the emergency room because the pain just got pretty unbearable.
Okay. Now you had x-rays taken. You did, yeah?
Yeah.
And that x-rays, we know, look for broken bones. You didn't break any bones, right?
No, luckily I didn't have any broken bones.
Did you hope that the pain would go away?
Yeah, I mean, I thought the pain would go away. I mean, I assumed it would. I mean, I was hoping it would.
So let's fast forward a little bit for time. When that first night you were having pain, headaches, neck pain, shoulder problems, and back problems, did some of that pain actually did go away, but some remained?
Yeah, that's correct. My left shoulder pain kind of went away. The headaches, they were kind of off and on. Sometimes it would be unbearable for me to sleep. I mean, I would wake up sometimes from the headaches after that. But those eventually went away. Neck pain kind of stayed, in the low back pain got worse, though. It was pretty bad.
From that time until now, did you seek attention from qualified doctors like orthopedic surgeons and management specialists?
Yes, I went to orthopedic surgeon, and they gave me some injections in my back for my back pain. I did that about 3 times. It helped, but temporarily. I mean, it helped for like a few days, a few weeks, but then the pain would come back. So then I would go get another one. Again, kind of temporary type relief. I mean, the pain went away, but then it would just come right back after a few days or a couple of weeks.
Yeah, have you ever heard the term conservative treatment or more conservative treatment? You know what I'm talking about?
Yeah, I mean, I think that's what the doctor told me that they were doing when they saw me. They were saying, hey, this is just conservative treatment. It's not, if it works, hopefully it works, and hopefully it works for a long period of time.
And so ultimately, after you tried 3 different rounds of conservative treatment with injections that didn't work, did a doctor recommend that the last alternative is for you to have low back surgery?
Yeah, I mean, right before the pandemic, because after that last injection, it worked temporarily, but then pain came back, and then the doctor said, hey, you can't get any more of these injections. They're not going to, relieve you. And he wanted me to do a surgery. And I mean, surgery sounds, for a guy my age, would never want to go through a surgery, but the pain was so unbearable. So I wanted to do it. Then COVID hit, and, I was just unable to get a surgery on schedule.
So you're 38 now.
Correct.
Is the pain bad enough? Well, strike that. Did you and the doctor talk about if you got surgery, what's going to happen in the future?
Yeah, we talked at length because, he mentioned surgery and so we spoke at length about it. And he told me, look, this is your next option. This is what's going to happen. But as you get older, at some point the pain might come back, and that's due to, you know, multiple factors, the way you explained it to me.
Knowing that if you have surgery now, that as you get older, it's gonna come back and be worse. You still want to have surgery now? Is it that bad?
Yeah. I mean, I go through my days, you know, I have to take medication just to, you know, kind of get up out the bed, you know, pain medication just to get out the bed. And, you know, I don't want to get addicted to pain pills or anything like that. And, you know, I never thought that, you know, I would have trouble, you know, doing things like going to the gym, or can't even play softball or basketball like I used to. I used to be really active. I mean, I played sports in high school. I played, you know, baseball, basketball, and football. And you know, before, you know, the pandemic, I was playing pickup game basketball, basketball pickup games. And can't do that anymore. Played in the softball league. I mean, it's just, pain is just too unbearable for me to even stand up and try to swing it back.
The last couple of questions, and I want to finish with what you were just talking about. I want you to assume, let's assume that you remember that you saw a doctor that this defendant had hired, and they did an exam of you. Remember that?
Yeah.
Sir, can you ask that question again? I didn't hear it.
Sure. Do you remember that this defendant hired a doctor and you went to go be examined by that doctor? Remember that?
Yeah.
And you were honest with that doctor when he asked you about your activities in sports work in your past?
Yeah.
Did you try,
Absolutely.
when he asked you to show your strength or your flexibility or movement, did you do everything that he asked to the full extent of your ability?
Yes, sir. Sure
And
did.
I think you even heard in opening that you were strong and you could move. That's true, isn't it?
That's true.
You're not like lollygagging or making it over exaggerating, you're trying hard. Yeah.
Yes,
So
sir.
in your past, when you played sports, when you played basketball, softball, you ever have these headaches, neck pain, low back pain, anything like that? In the 30, once you got to be 5'6" in the last 30 years?
No. I wasn't having any pains like that.
No further questions. Thank you.
Mr. Alder, thank you. Mr. Schonbuch.
Yes, Your Honor. So, Mr. Plaintiff, were you or were you not on your way to a big meeting that morning when this incident occurred?
I was on my way to work. We have meetings at work, but I was on my way to work.
So, you heard Ms. Defendant talk about your interaction with her at the accident scene, with you yelling and dropping an F-bomb and calling her a stupid old lady and all that. Are you saying that she's completely making this up?
Yeah, I never called her. I never called her an old lady, and I never cussed at her.
Weren't you annoyed? I mean, you had an accident here. This woman rear-ended your car, and now you're going to be late to work, and you had to wait there. The police are coming. That didn't bother you at all? You weren't upset?
I was just upset more because she seemed to blame me for running into the back of me. I mean, she was saying that I stopped short, and she was yelling at me like I did something wrong.
But you never let that upsetness get to the point where you were cursing at her or calling her an old lady or anything. She's just completely lying about that.
I never cursed at her, and I never called her an old lady. No.
All right, so let me ask you, when we took your deposition in this case, you were asked about giving us a description of the accident, and you told us that it was like an explosion. Do you recall that?
Yeah, I think I said it was a loud boom, or it sounded like a loud boom.
Well, let me be clear. You did say loud boom, but you also said the impact was like an explosion. Don't you recall using that word?
I don't recall using that word, but you know.
Well, you did say it was a loud boom. You do agree with that, right?
Yeah.
All right. You're saying you don't remember saying that it sounded like an explosion, or you're saying you didn't say it?
I was just saying I don't remember saying it sounded like an explosion. I don't recall that what you call it, a deposition. I think it was a while ago. I don't remember exactly what I said.
All right. Well, let me do this. I'm going to read from the plaintiff's deposition, page 15, lines 16 through 18.
You have that in front of you, Mr. Alder?
I do, Your Honor, no objection.
Go ahead, Mr. Schonbuch.
Thank you, Your Honor. Question: how would you describe the impact? Answer: I was just sitting there and all of a sudden, boom, it sounded like an explosion. I was in shock for a minute or two. Now, let me ask you something. Before you went to any personal injury lawyer in this case and before your lawsuit was filed, isn't it true that you told the doctor on the very evening of this accident that the impact was light?
I don't remember saying that the impact was light. I mean, I went to the emergency room afterwards, but I don't remember telling any doctor that the impact was light.
Okay, so let me ask you, you did go to Los Angeles Hospital, correct?
Correct.
And your date of birth is 1982, correct?
Yes, sir.
And you went on April 2, 2019, correct?
Yes, sir.
And your name is Mr. Plaintiff, correct?
Yes, sir.
And you were there because of a motor vehicle accident at approximately 9 a.m., correct?
Yes, sir. Yeah.
And
I think
your,
it happened around that time.
okay, and your airbags did not deploy. You told that to the doctor, correct?
I don't even remember telling the doctor if my airbags deployed or not. I don't remember anyone asking me that, but.
All right. You don't remember telling the doctor the impact was light, using that word light.
I don't remember how I described the impact of the doctor. I think I was more focused on my pain.
All right, well, let's pull up then for our tech. If you could pull up Exhibit 4-1, just the top part where it's chief complaint.
You've been shown this exhibit, Mr. Alder?
I have, Your Honor, and we've stipulated to the admissibility of the records. So,
All right. Very good. So you can put it up, Mr. Schonbuch.
Thank you, Your Honor. All right. Again, you see that? That's where you went to the hospital, correct? Los Angeles Hospital, right?
Yes, sir.
Okay. Look at that top section there, chief complaint. No airbag deployment, no LOC. You understand that means loss of consciousness? Do you know what that means?
I don't know what that means. I didn't know that
Okay.
that's what that meant.
Were you rear-ended while at a complete stop?
Yes, sir.
Okay, but you don't recall telling the doctor that the impact was light.
I don't recall that.
Okay, thank you. Okay, Mr. Tech, we could take that down. All right. So let me ask you here. Do you dispute the comment in the records about you saying that the accident was light only a few hours after the accident happened? Do you dispute that as being untrue?
I mean, I don't think it was light. I just don't remember saying that to the doctor or to the emergency room doctor. I don't remember saying that. But it sounded like a loud boom, and I was in pain when I went to the emergency room. I mean, my pain was what I was focused on.
Okay, but when you told us that the accident was a loud boom and felt like an explosion, all that was like a year after this accident happened. Isn't that true when your deposition was taken?
I believe, sir. So, yeah.
Okay, so 10 hours after the accident happens, the records show you say that the accident was light, but a year later after the lawsuit's filed, it's an explosion and it's a boom. True?
again, I don't remember saying light, but
Okay, well, let me ask you this then. And I don't mean to be sarcastic here, but as time goes on, does your memory get better and better and better? Or do you think your memory is better kind of close to when something happens?
I mean, I think it would be better when it's closer. I mean, I just don't
Okay.
remember exactly what I said to the doctor, though, you know, with regard to the impact speed.
All right, well, let me ask you some other questions. There wasn't an ambulance at the scene, true?
That's correct, sir.
No paramedics at the scene, true?
Correct, sir.
Police did not prepare a report, true?
That's correct, sir.
And you didn't go to a doctor right away, correct? You went to work, correct?
That's right.
And you worked the entire day, isn't that true?
Yeah, I worked the entire day. I worked through the pain.
Right, but you didn't like have a half day that day, did you?
No, I did not.
And you didn't go home to rest that day. You finished your work day, true?
That's correct, sir. Yes.
And when you went to the doctor that night, you drove yourself there, isn't that true?
That's correct, sir.
True, you did not call an ambulance to take you to the doctor, right?
I did not call an ambulance.
You didn't call for a paramedic that night, did you?
No, I went straight to the emergency room.
And you didn't take a taxi cab there, did you?
No, sir.
Call for an Uber or a Lyft?
No, sir.
Drove over yourself, true?
That's correct, sir.
Parked in the visitor's lot, right? You didn't pull up to the emergency section, did you?
I don't remember where I parked. I don't remember where I parked, but I parked where I could park and get as close as I could.
But I mean, you parked in a lot and casually walked in. They didn't like run over to your car with a stretcher and take you out into the ER, did they?
No, sir.
All right. You were wearing your seatbelt that day, correct?
Yes, sir.
And the airbags in the Prius did not deploy, true?
That's correct.
And when you went to the doctor that night, did they admit you to the hospital, keep you?
No, they didn't. They took the X-rays, and yeah, they didn't keep me overnight.
Right, no stay overnight, true?
That's correct, sir.
And the X-rays they took, they told you that they were all normal, isn't that true?
Right. They told me that luckily I didn't have any broken bones. That's correct.
You were discharged that day and sent home, correct?
Yes, sir.
And they didn't give you any prescription medication, isn't that true?
They told me to take, medication, over-the-counter medication for the pain.
Right, but what I'm saying is they didn't like give you a packet of Vicodin or pain pills from the hospital. Instead, they told you, no, just go home. And if you need to, go get yourself some Advil at CVS.
Yeah. Well, I don't know if they said CVS, but or Advil specifically. But.
Okay. And before you went to any other doctor, you went to a lawyer first. Isn't that true?
Actually relevant, Your Honor.
Ask the question again, Mr. Schonbuch.
Yes, Your Honor. Before you went to any other doctor whatsoever, you went to a lawyer first. Isn't that true?
Objection overruled. It goes to bias.
I went to a doctor in, I want to say, June. So yeah.
So yeah, you went to a lawyer first, and then afterwards, with the lawyer's referral, that's when you went to the next doctor.
I asked the lawyer to refer me to someone that could help me out because the pain was just getting unbearable, and I didn't believe, I should have had to pay for it.
All right, well, let me ask you though, just on the timing sequence, before you went to any other doctor, you went to a lawyer first, correct?
Correct, sir.
Did the doctor you went to, the one that was referred by the lawyer, did that doctor tell you that she has dozens of other personal injury patients that are referred to her by the same plaintiff lawyer.
Foundation calls for speculation.
Sustained.
Did that doctor ever tell you during your treatment that she has testified in depositions and trials before for personal injury plaintiffs represented by the same attorney?
Same objections as counsel knows, Your Honor.
Sustained. Sustained. Move to a different area, Mr. Schonbuch.
Yes, Your Honor. Did that doctor tell you that the MRIs taken of your neck were completely normal?
Yeah, I think she said that they were, normal, that there was nothing bulging or anything.
Okay, and on the low back MRIs, did that doctor ever use words to you like degeneration, desiccation, and disc disease?
I don't remember her saying that. I mean, I think she said that I had some problems with my disc.
Okay, but she didn't oh, I'm sorry, go ahead.
I think she said problems with my disc in my low back.
Okay, but when she describing those problems, she did or did not use the words degeneration, desiccation, and disc disease?
I don't remember her saying those words exactly, no.
Did that doctor ever tell you that your years of playing tackle football and baseball and softball and basketball can take its toll on the body as the body ages?
No, no.
How many years did you play tackle football, by the way?
Just 3 years in high school.
And since then, it's been baseball, softball, and basketball?
No, just since then, it's pretty much just been pickup game, basketball, and softball. I started softball probably about a few years ago.
And lastly, did that doctor that you went to, the one that you were referred to by the plaintiff attorney, ever tell you that as the body ages and as you get older, that the body develops degeneration, desiccation, and disc disease?
No.
Okay. Thank you very much, Mr. Plaintiff.
Thank you.
Mr. Schonbuch, thank you. Mr. Alder?
So, yes, thank you, Your Honor. So, Mr. Plaintiff, you were called a liar. You're lying about what happened. Feel.
Mr. Alder, ask the question again. We got a.
So, Mr. Plaintiff, how's it feel to be called a liar about everything?
I mean, it doesn't feel good at all.
Wait, aren't you making all this up? And you hired a lawyer to make sure immediately that you could get as much money as possible? Didn't you do that?
No, sir. Absolutely not.
You're not doing a very good job at it if you drove yourself to the hospital. You're not a very good liar.
I drove myself to the hospital because I was in pain. I mean,
Yes, sir.
I
You
didn't.
did things like take care of yourself. You told people about your injuries when they were not very bad. You drove yourself. You didn't exaggerate. You didn't run to surgery, right?
Correct. Yeah.
So
Exactly.
you did everything conservatively, trying to take care of yourself and be a good employee, go back to work, and now you're called a liar.
Yeah. I don't. I mean, it's a shame. I mean, I'm just trying to get better. I'm just trying to,
Pretty good idea that you needed a lawyer, right?
I would think so. Yeah.
No further questions.
Mr. Schonbuch, recross.
Nothing, Your Honor. Thank you.
All right, very good. Mr. Plaintiff, thank you. Thank you for your testimony. And
Thank you, Your Honor.
Mr. Alder?
Thank you, Your Honor. Plaintiff's witness would be the plaintiff accident constructionist, Miss Accident Reconstructionist.
All right, very good. Miss Accident Reconstructionist. you're present via Zoom. Thank you for being present. I want you to raise your right hand, repeat after me. Well, do you swear to tell the truth, the whole truth, or nothing but the truth?
I do, Your Honor.
And state your full name, spell your last name for the record. Your first name is fine for this purpose. Go ahead.
Miss Accident Reconstructionist.
All right, very good. Mr. Alder, you may proceed.
Thank you. Good morning.
Morning.
So you are what we've called an accident reconstructionist. That's someone who can look at different facts and evidence to recreate what actually happened in this case.
That's correct.
Have you done that in this case?
I did.
And so you're going to be able to tell us based on an objective things, the real speeds that the defendant was going at the time?
Yes, I was able to calculate that.
No way of faking that?
No, it's based on scientific certainty.
So tell us before we get into what the science shows the real speeds were in this accident, kind of what generally you needed to look at, and then we'll talk about how you got to your opinion.
Yes. Well, I was provided with certain materials, including I read the plaintiff's deposition, the defendant's depositions in their entirety. I looked at color photographs provided to me of both, just of the plaintiff's Toyota Prius. I did not receive photographs of the defendant's vehicle. I also reviewed a property damage estimate of the plaintiff's vehicle, which was a Toyota Prius 2015, and I looked at some discovery documents, written discovery.
Okay. Now, as an accident reconstructionist, you are an engineer?
Yes,
And as part of being an engineer, do you have available to you crash tests that different types of vehicles of different weights have been crashed together and you see the results so that we can compare them to the results in, say, this accident?
yes, I have access to different databases, including national databases that compare vehicles similar to the vehicles involved in this accident, so that you can look at that data and then compare it to these actual vehicles. There's hundreds of different accidents that are included in the database on a national level that we have access to.
All right. I think maybe a lot of people have seen commercials of the talking dummy that gets the crash dummies, and those are filmed by different car companies and different engineers in every conceivable way to give us information that exactly like what you're looking for to rely on here. Is that right?
In addition to the crash test dummy samples that we also have access to real life collisions.
So I want to ask you about a couple of things we've heard so far. One, if the defendant had actually taken photos of her car, which she didn't, but let's assume that there was no damage to her car. Given that her car weighed almost over half a ton more than the plaintiff's vehicle, are you surprised that there might be little or no damage to the defendant's car, but more damage to the plaintiff's car?
Not at all. We know that the 2015 Prius has a load weight of 2,794 pounds, and the loaded weight for the Ford Explorer was 1,148 pounds greater at 3,942 pounds. So it is comparably a much heavier car, and it is not a surprise, and it is actually expected that the Ford Explorer would not sustain either the extent of damage that the Prius did or any damage at all.
So when a big deal was made about, well, there was no damage to my car, given the weight difference, are you surprised at all? Does that really mean anything as to whether or not Mr. Plaintiff's car got a really substantial hit?
It is not surprising, nor is it inconsistent with the damage to the vehicle in front, the plaintiff's vehicle.
You know, talking about other things that maybe don't make that much of a difference, an airbag going off, don't they only go off if there's a front impact? In other words, the Prius would have gotten to have the hit in the front of the Prius?
You can get a rear airbag or rear impact air deployment at greater speeds but generally speaking, unless you get that threshold speed, you will not get airbag deployment.
So what does, if anything, the fact that the airbags not going off in the front mean in this accident at all?
Only to say that this was not a high-speed impact.
Got it. Have you been able to calculate to a reasonable degree of scientific certainty what speed this defendant was actually going and not the 4 mile an hour or less speed that she told us under oath?
Yes, based on the estimate of repair and the photographs, I was able to make the calculation that Miss Defendant was traveling at an impact speed of 11.7 miles per hour to 12.3 miles per hour within that range.
So when the jury is determining who's telling the truth, what actually happened, we want you to assume we heard the defendant say, I didn't even know there was an impact. I was going 4 miles an hour or slower, yet the science says she was going at least 3 times faster than that. True?
True.
And this impact that she did not even know occurred, that she was curious to see if there was anything, actually resulted in over $5,000 worth of damage to the Prius?
That, according to the estimate, that's true.
Now, lastly, as an engineer and an accident reconstructionist, are you able to take a vehicle that is stopped and a vehicle that hits it at 11 to 12 miles an hour and calculate how much force that would have put on Mr. Plaintiff's body to see if it felt like a boom or an explosion or something else?
Well, if I'm understanding your question from a biomechanical advantage or point of view,
Yes.
based on the speed at a range from 11.7 to 12.3 miles per hour, hitting a stopped vehicle, there would be enough force to cause an injury.
Okay.
That's
And
what the question is.
lastly, the amount of force, the G forces that was put on Mr. Plaintiff, who was stopped, hit by a over half a ton heavier vehicle at 11 to 12 miles an hour, you have is a change in speed of over 8.5 miles an hour. Is that right?
That's correct.
Does that mean that Mr. Plaintiff, unaware that he was going to be hit, stops and suddenly gets pushed forward 8.5 miles an hour in a millisecond?
That's correct. That's the rate of acceleration for the Prius.
That could feel like a lot of things, yeah?
Certainly, getting hit at that speed would definitely be a force applied to your body that could cause an injury.
Thank you, ma'am. No further questions.
Mr. Alder, thank you. Mr. Schonbuch, cross.
Yes, Your Honor. You never inspected plaintiff's Prius, is that true?
It is true. It had already been repaired, so I didn't think that that was relevant.
And speaking of the repairs, by the way, let's go to the property damage exhibit for our trial tech. If we could pull that up.
What exhibit is it?
2, Your Honor, and I'm going for page 2, so we've marked it as 2-2.
Thank you.
There we go. Let's go all the way to the top there. All right, good. Now, Mr. Plaintiff Attorney mentioned that there was like $5,000 of damage to the Prius. This was a rear-end accident, correct?
That's correct.
And was the Prius pushed into any other object, like another car or a telephone pole, or smashed into a house or anything like that?
Based on the plaintiff and defendant's deposition testimony, I do not believe so.
All right, so let's look at the top repairs there on Exhibit 2-2. You see where it says front bumper and grille, and it says recondition the bumper cover and replace the lower grille and replace the seal to the hood and the front lamps and all that. You see that at the top there?
I do, counsel.
Okay, all that's part of this big $5,000 that was mentioned by Mr. Plaintiff Attorney, isn't it?
It looks like about 260,000, or excuse me, $260 of it approximately was.
Well, no, you're looking at the price of the parts, but look on the paint section on the right, there's also 3.3 hours for reconditioning and painting the front bumper, 1.3 hours for you see there's extra charges there. Do you see that?
Yes, a portion of this estimate is related to front end damage.
Okay, do you have any idea why, without having any impact to the front of this vehicle, why the plaintiff is trying to recover money for damage to the front of his Prius from my client, Ms. Defendant?
Well, I don't have any information one way or the other whether or not the plaintiff is trying to recover that particular damage, but if that's what you're telling me is happening, but that damage, as I understand it, was not related to the impact in this case.
Okay, and then also on the property damage estimate, isn't there a lot of charges for, let's see what it says, a lot of paint blending on the rear quarter panels and things of that sort?
Yes, they had to replace paint or repaint.
Right, and it was $1,500 worth of this was to fix and repaint the plastic bumper cover, which is made out of plastic, true?
Correct.
Okay, and you agree that rear bumper cover is made of plastic?
Mr. Schonbuch,
Yes, Your Honor.
can you orient the jury and the court as to what you're referring to on this document?
Oh, you know what? Thank you, Your Honor. I have a better idea. I'm going to get rid of this document and just ask questions. So let's, Mr. Trial Tech, if we could remove that, that would be better. Thank you for catching that, Your Honor.
Thank you.
Okay, so you would agree, Ms. Accident Reconstructionist, that the rear bumper cover is made of plastic, true?
Correct.
And we indicated about $1,500 worth of the property damage was to fix and repaint the piece of plastic on the back of the car, correct?
Correct.
And this had an imprint of the Ford's license plate frame bolts in it, true?
I'm sorry, could you restate that again?
Sure, the plastic rear bumper cover had an imprint of the Ford's license plate frame. The bolts from the license plate frame were kind of indented into that plastic.
Yes.
And the
front grille.
And the bumper cover that we're talking about is not even the actual bumper. Isn't that true? That the bumper is located underneath the bumper cover.
Yes.
And the actual bumper, at least according to Exhibit 2, which is the property damage estimate, was not even damaged in the accident. Isn't that correct?
The bumper itself?
Yes.
Correct.
And the actual bumper was not repaired or replaced or touched by any repairs in this case, true?
The actual bumper was not, the bumper cover was.
Okay. And the lift gate in the back of the Prius, that's what's made of, constructed of unreinforced metal. Isn't that true?
Yes, it's constructed of metal.
Right, but it's unreinforced. In other words, there's no frame behind the lift gate, correct?
Correct.
And there's also no pillar behind the lift gate. In other words, a vehicle has an A pillar and a B pillar and a C pillar, but the lift gate doesn't have any pillars behind it, true?
That's true.
And that's because the lift gate needs to be light and easy because you want to lift it because it's a lift gate, correct?
Correct.
And isn't it true that even the rear window in this Prius, which is made of glass, obviously, was not broken in the accident?
That's correct.
And there was no damage at all to the rear quarter panels of the Prius, but instead the charges referenced on Exhibit 2, which is the property damage, was solely for the paint blending from the rear plastic bumper cover over to the quarter panels on the side, true?
That's correct.
And there was no frame damage to the Prius, true?
Also correct.
The Prius didn't have to go on the frame straightener to be as part of its repairs, true?
Not according to the estimate.
Okay. And isn't it also true that in terms of what using automobile body repair lingo, that the damage to the Prius is completely what's called cosmetic? Isn't that true?
Yes,
And in fact, the plaintiff drove the car straight to work that day. In other words, there was nothing wrong with the car in terms of its drivability, true?
correct. There was no structural damage that prevented it from driving.
But it didn't need to be like aligned or the wheels needed to be balanced or anything like that. It was perfectly straight in terms of its driving, true?
According to the estimate, that's correct.
Okay. And according to the analysis in this case and your accident reconstruction, the Prius was not propelled into anything else, correct?
It was propelled forward, but as I understand it from the testimony, it did not strike anything in front of it.
Okay. And there was some discussion about the airbags before. The airbags did not deploy, correct?
That's correct.
Isn't it true that this particular model year Prius, the airbags will deploy in a rear end impact of about 11 miles per hour?
Approximately 12 to 15 miles per hour, counsel.
And you say the closing speed here was 11.7 to 12.3, correct?
Yes,
And you have the delta V, what is 8.1 to 8.6?
yes.
And let me ask you, a delta V, when you sit into a chair, in other words, you've had a long day at work and you come home and you plop into your chair and turn on the remote control because you're going to turn on the game, the football game, which we're going to do right after this program today. When you plop down into that chair, what's the delta V?
Well, I can't give you a definitive delta V for somebody who's plopping into a chair. I've been asked this question before about, well, if someone falls to the ground or steps off a curb, there are not comparisons and research done on that, but you can get a delta V from just the movement of your body. Whether or not it's the exact as this one, I could not tell you that.
Okay, well, without being exact though, can't you give us an approximation? In other words, isn't it true that if you were to plop down into a chair, and I mean, when I mean plop, I mean, you're dropping down into the chair. Isn't it true that the average delta V is about 5?
Well, we can't compare apples and oranges. If I plop into a chair at my weight versus a linebacker, who plays for the Rams plopping into a chair, you're going to get a different delta V, obviously.
And the delta V would be higher or less for the tackle football player?
Could be less, actually.
And what about on a delta V stepping off of a curb? Isn't it true that's about 5?
I would say it would be a range of 2 to 5.
Okay. All right. And you saw in the file materials that Ms. Defendant is about twice as old as Mr. Plaintiff,
Correct.
and that Ms. Defendant didn't feel any impact at all. In fact, she didn't even know there was contact between the vehicles.
Well, that was her testimony, but it's not consistent with the property damage estimate nor the photographs.
Right. I'm just saying, I'm not disputing that there was contact. It's more, I'm asking you, you saw in the materials that she said she didn't even realize there was any contact. In other words, she had no experience of contact.
That was her testimony.
And that she was surprised that there was any contact at all.
Correct. That was her testimony.
And that she wasn't injured at all.
Same. That was her testimony.
Okay. Thank you very much. No further questions.
Mr. Alder, anything else?
Yes, Your Honor, thank you. Miss, I want to bring us back to the science. And you've indicated that the science and the engineering and physics show that what the defendant said isn't consistent. True?
That's true to a reasonable degree of scientific certainty. That's true.
And so instead of just saying things, I want to talk about the science. So Mr. Schonbuch just asked you about, well, if we plop down, isn't that the same as being in a rear end accident? Isn't that the delta V, the change in speed, about the same? But that's radically different for a number of reasons, isn't it?
It is.
So when you plop down, the forces may be approximately the same, but what's the difference when you expect to plop down versus when you have no idea and then you get hit? Does that make a difference?
It absolutely does make a difference when you deliberately step off a curb, you deliberately sit down into a chair, your body is so-called braced for it, expecting it, you engage muscles to brace for the so-called impact, which is not what happened as I understand it in this case, because according to the plaintiff's deposition, he did not see the impact coming.
And when we scientifically, it has been studied, when we're not expecting to have forces put on it, does it make us more likely to be hurt?
Yes.
Secondly, applying science, not just a general statement, when you plop down in a chair or step up on a step, that usually takes a lot longer time where the force is applied as opposed to a millisecond or two in an impact, true?
Yes. The forces applied when you're sitting down or stepping up or off of a curb, it happens gradually.
So when a unanticipated force happens to our bodies in a millisecond, not when we are anticipating sitting, is the chance of us getting hurt substantially higher.
It is significantly higher.
So applying the science is completely different than just making generalized statements about, well, I didn't think it was that big of a deal. True?
I would agree with that.
Lastly, just to be complete, Mr. Schonbuch pointed out that some of this damage in the report is about 6 hours of paint and repairs for unrelated stuff. So that's about, according to $56 an hour, about $350, let's say $400. So I want to take that out of the $5,100 estimate, just to be completely open and upfront. $4,700 worth of damage caused by this accident to someone who says, it was so light, I didn't even know that there was an impact. Is that inconsistent along with the damage to the vehicles, completely inconsistent with what the defendant described?
It is inconsistent with what she described.
Thank you. No further questions.
Mr. Schonbuch?
Yes, one follow-up, Your Honor. So let me get this straight. The only difference then between this accident and plopping down into the chair is that the plaintiff was not expecting to be plopped down in the chair.
No, that's not my testimony. I think that the forces are different. You can't compare somebody plopping down to a chair for the reason I stated on our last time when you questioned me regarding the different weights of people, how slow you're going to be sitting down into the chair. Are you putting your arm back first? What's the height of the chair? There are different things that go into it, so I can't compare it to a real life impact between two vehicles.
Your Honor, we would move to strike everything after the word no.
Submitted, Mr. Alder?
Submit, Your Honor.
All right, it's stricken. So, ladies and gentlemen, what was the last word that you asked the court to strike from the witness's testimony? Mr. Schonbuch, just remind the court, please.
I can't remember the first word to be stricken. I just remember the last word, which was no.
All right, so the latter part of the answer of this witness is stricken from the record. You're not to consider it either at this time or at any time, including during deliberations. And nothing further for this witness, Mr. Schonbuch?
That's correct, Your Honor.
Mr. Alder, anything else?
No, sir. Thank you.
All right, ma'am, thank you. Thanks for coming in. We appreciate it. You're free to go. Mr. Alder, any further plaintiff witnesses?
No, Your Honor, at this time, the plaintiff rests.
Mr. Schonbuch, any defense witnesses?
Yes, Your Honor.
Do you want to proceed now or take a short break before you begin the defense case?
Well, the schedule is completely up to the court, Your Honor. Whatever you'd like to do is okay with us.
Mr. Alder, you want to proceed?
Yes, Your Honor. I would prefer to finish this witness and then take a break.
Very good. Mr. Schonbuch, call your first witness, please.
Thank you, Your Honor. The defense will call Dr. Defense.
Dr. Defense is present. Raise your right hand so I see where you are. All right, sir, raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, very good. Mr. Defense Orthopedic Expert, I think we all see you. Mr. Schonbuch, you may begin your direct examination of this witness.
Thank you, Your Honor. Can you tell the ladies and gentlemen of the jury what you do for a living?
I'm an orthopedic surgeon.
And where did you go to medical school?
I went to Harvard Medical School where I was the valedictorian. I'm also pleased to say that I graduated with a perfect GPA.
And what else do you do in your time besides being an orthopedic surgeon?
Well, at the time that I was at Harvard, I also worked full-time at a social services clinic. After graduation from medical school, I was able to adapt that to include a medical clinic as well, and I continue to support that clinic and other clinics here in California.
Thank you very much. Now, you examined the plaintiff, Mr. Plaintiff in this case.
I did.
You were hired by my office. In other words, we made the arrangements to have you examine Mr. Plaintiff. Is that true?
That is correct.
And you've been paid for your time to conduct that examination, review the records, and even being paid for your time to come into court today to testify, correct?
I am paid for my professional time, as are most professionals.
Okay, and when I say come into court, I mean obviously through the Zoom process, paid for your time here, even though it is obvious based on your background that you are at your medical office, true?
There's a lot of telemedicine going on these days.
Okay, all right. Now, when you actually got to meet with the plaintiff in this case to conduct your examination, did you take a history?
I did take a history.
I'm going to ask you some questions about the history. What did the plaintiff tell you about whether or not his airbags had deployed in this accident?
He indicated there was no airbag deployment.
What did the plaintiff tell you about whether or not he had lost consciousness?
Again, no loss of consciousness was reported by the plaintiff.
What did the plaintiff, Mr. Plaintiff, tell you as to whether or not he sought immediate medical care?
He indicated that he went to work immediately after the accident and he sought the emergency room later that evening after work.
And did Mr. Plaintiff tell you that how he drove to the hospital that evening?
He indicated that he drove himself.
And did the Mr. Plaintiff tell you that he, as to whether his next doctor appointment was before or after he hired a personal injury lawyer?
He stated that he first hired a lawyer and was referred by that lawyer to an orthopedist.
And as far as you know, up until today's date, has the plaintiff undergone the surgery that he had referenced?
No, he is not.
Did he tell you whether or not this alleged surgery has even been scheduled?
As far as I understand, it has not.
All right, now I want to ask you some questions about your examination portion. Did you get an opportunity to examine the plaintiff at your office?
Yes, I did.
Okay, and what did the plaintiff tell you during the examination about his range of motion?
He claimed that his range of motion was limited. My observations for the examination indicated that there was some guarding in some certain exercises, but generally speaking, his range of motion in much of his orthopedic body was fine.
Let me ask you something before we go on a little further here. You familiar with the terms objective and subjective as applicable to an orthopedic surgeon's examination and evaluation?
Yes, I am.
When someone claims that they have limited range of motion, is that, in your view, a subjective or objective complaint?
That is subjective. That is the patient identifying for themselves things that they claim to be a problem, but not necessarily things that can be identified by either test or third-party observation.
Okay, let me give you another couple examples. How about when someone has a blood test? Blood is drawn, and then there are certain elements found in the blood that you read from a lab report. Is a blood test subjective or objective?
That's an objective evaluation because the blood is subjected to testing, which can then be evaluated by basic standards that are used by all physicians.
How about reflexes? And that's when you have that little hammer with the little piece of rubber, the triangular piece of rubber, and you tap someone on the knee there and you do a reflex. Is a reflex test subjective or objective?
For orthopedists, a reflex test is an objective test, and there were additional objective tests that I performed on this patient.
Right. All right, I'm going to go through some of those. First of all, did the plaintiff tell you whether or not he's able to perform all his activities of daily living?
He indicated that he was capable of performing all of the activities, including driving both to the hospital on the day of the accident and to my appointment.
When you examined him, did he complain of lumbar spine pain, low back pain?
He did, and to the extent that he has complained about lumbar pain, that's consistent with his complaints on the day of the accident, where spasm of the lumbar area was noted. But again, that's a subjective claim.
Okay. And what about your examination? Did you perform any tests of the hips and pelvis regions?
I did. I performed range of motion tests, and most important, I performed a Patrick maneuver. The Patrick maneuver has the patient lying on their back and the legs are crossed in a figure 4. The patient is then tested to see whether there's any pain on either side. And in particular, it's designed to test whether there's any pain at the sacrum, at the L5-S1 level. And in this case, the Patrick's test was completely negative, indicating there would be no objective findings of injury or chronic issue or acute issue at that level.
Okay. When you say a test is negative, normally outside of the medical field, when someone finds out something negative, that is generally not good. But when you use the word negative, does that mean that there is an issue or there is no issue?
There is no issue because the test produced no response, no reaction, no expression of pain. Therefore, the test is negative for any problem.
How many different range of motion tests did you perform on the hips and pelvis regions?
I performed 6 standard tests: flexion, extension, abduction, adduction, internal and external rotation. They were all within normal limits, meaning that the patient could easily perform the tests without expressions of pain or discomfort.
Okay. And then what about lower extremity neurological examinations? Did you perform any of those?
Yes, and we assess whether the patient is capable of moving through those tests with relative strength levels. We look to see whether the patients, for example, can move and express strength up to a level of 5. The motor strengths by this person were 5 out of 5. His sensory examination showed that he could feel all sensory inputs, and his deeper tendon reflexes were normal and symmetric.
And what about gait? What is a gait?
We watch the patient walk to determine whether they are having any difficulty planting their feet, moving their hips, or keeping their spine relatively straight. His gait was normal. He had a normal heel and toe walk. There was no need for him to use any cane or other assistive device.
All right. And as part of your work in this case, did you receive all of the plaintiff's medical records?
I did.
And as part of your work, did you review those medical records?
Yes, I did.
In your review of the medical records, did you find a section, the first day of the incident, where plaintiff described the level of the impact of this accident?
Yes, at the Los Angeles Hospital emergency room visit, he describes being involved in a motor vehicle accident and describes the impact to the doctor as light.
And is it your understanding that that was taken, that information was taken the very same day as this accident?
Yes, within 10 hours of the accident, according to the record.
Okay. By the way, did you also compare that to plaintiff's accident description a year later after the lawsuit was filed and he had his lawyer in place and he was being deposed at a deposition when he described the severity of the accident at that time?
I did.
Was the description a year later after the lawyer, after the lawsuit, and once the case is in litigation, was plaintiff's accident description consistent or inconsistent with the way he described it the very same day of the accident?
His deposition description was inconsistent with the way he described it on the day of the accident, and also, in my opinion, inconsistent with the claims that he made on the day of the accident.
And the deposition description about the severity of the accident, do you recall his testimony on that?
I believe he said it was a boom and like an explosion.
Okay. All right. In your review of the records, the LA hospital records, what were your conclusions about the motor strengths tests that were performed?
Examination shows that his motor strengths were normal. As I indicated earlier, there was some low lumbar spasm, but no lumbar injury. The x-rays showed normal cervical and lumbar scans.
Okay, and did you also, as part of your work, review the records from the Orthopedic Center of Santa Monica?
I did.
And what of relevance to your examination did you conclude with respect to plaintiff's cervical MRI?
The cervical MRI was normal, and to the extent that that's consistent with his complaints of sprain and strain, I would not have expected it to be anything other than normal.
Okay, and what were the results of the lumbar spine MRI taken at the Orthopedic Center of Santa Monica, the first set of MRI?
The June 5th, 2019 records show that there is a desiccation of the disc at L4-5. There is a protrusion, but to the extent that that protrusion has caused any particular issue, it's hard to tell from the report itself. The L5S1 shows an additional protrusion in the opposite direction, but the most important aspect of this is the fact that the disc is desiccated, meaning that it is deteriorating and losing liquid in terms of its support for the spine.
Based on your experience, is desiccation something that is caused by a trauma?
Absolutely not.
What causes disc desiccation?
Age and individual action, depending on how active a person is.
Okay, let's go to the next MRI of the low back, which was October 16, 2019. Did you have an opportunity in your work in this case to review those films?
I've reviewed the films and the reports.
And what is your conclusion on the films and reports with respect to the October 16, 2019 low back MRI?
Well, interestingly enough, they do not identify the same disc protrusions in either direction, but they do point out that what the findings are degenerative disc disease, both at L4-5 and at L5S1.
What does that mean, degenerative disc disease?
It means a process that takes place over time. It's a process that occurs as someone gets older, and it does not necessarily mean someone has to be older in order for the process to start. Degenerative disease is something that's a chronic, ongoing condition and has no acute or immediate cause.
Okay, lastly, I want to go to your final conclusions in this case. What are your overall conclusions with respect to these MRIs that were taken?
The extent that they show degenerative disease, and desiccation, by the way, is an aspect of degenerative disease. This is an ongoing long-term effect. There is nothing that indicates that there was an acute problem. Further, based on the actual testing that I performed in my office, there does not appear to be any actual injury at the L5-S1 level because there was no response to the physical demands placed on the plaintiff at the time of that test.
Now, you mentioned earlier that desiccation is not something caused by a trauma. How about disc degeneration? Is that something caused by a trauma?
Degeneration? No. It is caused by a long-term, ongoing chronic process that may have its origin well beyond anything that's happened recently.
Okay, couple last questions. Plaintiff has submitted a bunch of medical bills in this case. Now, just as far as the amounts of the bills, did you review those and compare those to what is a customary charge out in the world here in terms of similarly situated doctors in our community?
I did.
What do you think about the amounts of those charges?
To the extent that those costs were actually required, the costs are reasonable and would be appropriate and would not be inconsistent with costs charged by other physicians and medical centers.
Okay, now what do you think about the medical bills being the claim that they were caused by this accident?
Oh, no, absolutely not. And I want to start, by the way, with the epidurals. I find that to be a surprisingly aggressive move on someone such as the plaintiff. They were unnecessary. This treatment was completely inappropriate and was not required by the medical condition that this particular plaintiff and patient showed.
And what do you think about then the other issue which has been raised, the fact that there's a claim that this Mr. Plaintiff is going to get a surgery in the future, even though there's nothing scheduled at all? What do you think about the connection or the cause of this claim for surgery as compared to this accident?
I think somebody has a boat payment coming due. There is absolutely no reason for this person to undergo surgery. And that he's experiencing is common for people his age, his background, and his athletic performance. There is no surgery that is required. His lumbar injury is minimal, certainly didn't even warrant the epidurals, and does not warrant surgical intervention.
What do you believe, in your conclusion, would be the appropriate treatment based on your review of the records, your examination of the plaintiff, all of the tests you performed, and the review of the cervical spine MRI films and the multiple lumbar spine MRI films?
I think this patient would be appropriately treated with what the medical community would call conservative treatment, which is physical therapy and over-the-counter medication as needed. And to the extent that he finds it necessary, he may find certain things like heat and cold massage to be helpful. Otherwise, I don't see any particular treatment other than that.
Okay. Thank you very much, Doctor.
Mr. Schonbuch, thank you. Mr. Alder, cross-examination of the doctor.
Yes, sir. Thank you. Doctor, good afternoon.
Good afternoon.
Sir, I didn't catch where you went to medical school. Where was that again?
That was Harvard.
Oh, at Harvard. So you're a well-educated man, clearly. Yes?
You can answer the question.
Oh, yes.
Clearly a bright, conscientious, hardworking person, right? Sir?
To think so.
Well, you told us that you were #1 in your class, had a perfect GPA. You seem proud of that, and you should be, right?
Sure.
Right. You understand then the importance of roles being appropriate. And as an expert doctor hired by the defense, you understand as a Harvard-educated, perfect GPA witness, you're not supposed to be an advocate for one side or the other, true?
True.
You understand that because you and Mr. Schonbuch have done this type of work together well over 75 times where he's asked you to be that independent witness. True?
I don't know exactly how many times I have testified.
Well, you have a perfect GPA. Can you give us an estimate, maybe even a ballpark of how often you and Mr. Schonbuch have worked together?
A number of times.
Can you be more specific? Perfect GPA.
This isn't part of the test.
That's a good answer. How much money have you made last year doing independent work like you're doing here today for Mr. Schonbuch?
You know, I didn't bring those records. I can't tell you an amount. I can tell you that 50% of the work that I generate, the fees I generate, go to those clinics I was telling you about.
Yes, sir. Well, I appreciate that. Another really good answer, but I don't really want to overemphasize it, but you brought up, you are Harvard educated, perfect GPA for a reason. So I ask you, as that person, can you even give this jury a ballpark of how much money you make as a defense expert? You got to know even a little bit.
It's probably six figures on a yearly basis.
So only 100 grand, but you charge $27,000 for just this case. Can't be more specific, huh?
Not without some records in front of me. You wouldn't want me to estimate or speculate, I'm sure.
Right. So I certainly wouldn't want you to speculate, but I wonder, as a doctor who's supposed to determine injuries, why are you reading depots and comparing versions of events? Isn't that being an advocate for the defense?
I want to be sure that I understand the complaints that are described accurately by individuals, including the plaintiff and the defendant under oath.
Yeah, but you weren't looking at what he complained of. You were looking at accident photos and a description of the impact. That doesn't sound very doctorly of you. It sounds more like an advocate. Wouldn't you agree?
No, I would agree that I would need to be thorough to look at each of the pieces of evidence that support the claims that are being made so that I can make an objective evaluation of those claims.
So you said that the plaintiff's claims were inconsistent with what you saw in the photos and in his depot, right?
Correct.
But you'd agree that every time he saw a treating physician, he consistently described the same types of problems, right?
He described the same subjective complaints.
You would agree with it when you saw him. He wasn't exaggerating. He answered your questions truthfully. He did what you asked him to do, correct?
That's true.
And you say that the test results were what you found and that those are objective, but really we have to believe that you are accurately reporting the results. That's kind of subjective on your part, right?
No, the training that we all have allows us to be able to tell when a patient is experiencing discomfort from a given test.
So doctors are trained for doing tests and they can tell whether a plaintiff is in pain or not for real, correct?
Absolutely. That's why patients tell us when they are in pain.
So the treating physician that saw Mr. Plaintiff multiple times, who recommended surgery, did the same tests that you did, and he found that it elicited pain, but you say it didn't. Isn't that kind of who we believe?
I did not see the same exact tests that I performed in his records. However, the range of motion tests were consistent with what I found, and some of the other tests were consistent with what I found.
Last couple of things, doctor. Degeneration means that as we age, our bodies kind of wear out, true?
True.
And a 38-year-old man has a 38-year-old neck and a 38-year-old low back. Same age, correct?
True.
And the body wears out 38 years the same way, true?
No,
No? So why is it that you have no degeneration in the neck that moves every day for 38 years, but degeneration in the low back?
we'd need a more thorough history to know that for sure. But his activities, as described in his history to me and in the other records, are consistent with degeneration from his sports activities.
So last couple of things, the treatment, even though you disagree with it, the actual treatment that he got, the charges were reasonable. Yes?
The costs were appropriate.
And for the doctor who recommended the treatment, it was reasonable for him to do that based on what his findings were and what he was being told, right?
I'm not sure I agree with that.
Well, different doctors see things different ways. That's why it's called the practice of medicine. True?
That's true.
Are you saying that this plaintiff's treating doctors committed malpractice?
I'm saying that in my opinion, this patient did not need the epidurals and does not need surgery.
But board certified surgeons looking at the plaintiff even more than you just happen to disagree. So different strokes for different folks, true?
I have some concerns about the need for surgery.
But what you're saying is you saw the plaintiff for 20 minutes and we should believe you and award this person nothing when he's incurred $75,000 of reasonable charges from board certified doctors that saw him way more than you. And because you disagree with them, then the plaintiff must be what? Lying? Or maybe,
I don't know that I would say the plaintiff is lying. I think his claims of injury, to the extent that they have been documented, are exaggerated significantly.
last couple things, sir. If Mr. Plaintiff came into your practice with no pre-existing problems, a young man of 38 who clearly feels well enough to do vigorous basketball activities with no pain whatsoever, gets into an accident and now has pain from then on, if this wasn't a case where you were hired by the defense expert and it was just a regular patient, you would say more likely than not that pain was caused by the accident, true?
I would say I would need more information before I can answer that question.
Really, the only difference between that plaintiff and this plaintiff is about $17,000 worth of charges that you're charging Mr. Schonbuch, right?
To the extent that I'm being compensated for my time, there is an element of truth to that.
And you understand that that's what the jury's trying to figure out as a Harvard-educated professional. Yes.
Sure.
Last time, sir, now that you know how important it is, can you give us any idea how much you made last year? Just think
I'm
about
sorry.
it.
Should have brought the records with me.
I guess that's what it took. No further questions. Thank you.
Mr. Alder, thank you. Mr. Schonbuch?
Nothing further, Your Honor.
Nothing further, Mr. Alder, for this witness?
No, sir. Thank you. But if I could request another break, please.
All right, doctor, thank you. Thank you for your testimony. You're free to leave. And ladies and gentlemen of the jury, should we take a slightly longer, how about a 15-minute, Mr. Schonbuch, 15 minutes, Mr. Alder, 15 minutes. And then maybe on that last 5 minutes, we can have a breakout session just with the attorneys in the court to do a sidebar to briefly discuss jury instructions.
Yes,
But
sir.
for the jury, back in 15 minutes. So I'm looking at my clock in the courtroom and it may be a little fast, but let's say it's 12:20. Why don't we have all jurors back at 12:35? Remember the admonition, don't speak about the case among yourselves or anyone else. We'll see you back in 15 minutes. And then the attorneys may be back in 10 minutes and let's try to do a breakout session.
Yes,
Without
sir.
fighting to the jurors. So we'll
Thank
see
you, Your Honor.
We'll see all the attorneys back in 15 minutes.
Yes, sir.
And then we'll see the attorneys back in 10.